Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of Hull & Hull, and I am very pleased to be here today with our co-founding partner, Ian Hull, and our associate counsel and dear friend, Jordan Atin. Here at Hull & Hull TV, we explore estate, trust, and capacity issues that may affect you. And today what we're going to do is go into an in-depth discussion about the topic of disinheritance, a fundamental estate planning issue that can potentially affect everyone. Jordan, how do you deal with disinheritance?
Well, it's obviously a very crucial issue, a very difficult issue to deal with. So if I have a client who comes in and expresses an intention to disinherit one of their children, for example, I'm going to do everything I can to document the reason, the rationale for why they're doing it. I'm also going to want to know, why did they do it the last time? If this is a change for them, what happened to make that change? And what specific event, and get as much detail as I can.
And Ian, what about you?
Disinheritance is a profound element of the estate plan. It's not always direct disinheritance, it's also indirect disinheritance, where you have a situation where you may not have given enough to someone within the group, the family, or a dependent. And so from my perspective, I really look at my job and what I do. If it's not fun, it's not worth doing. And when someone wants to come in and see me about any issues surrounding disinheritance, that is a red flag for me to say this is going to be a really good opportunity for me to work with the client or work with the court system to address what is in every element of every estate plan is that there's either direct or indirect disinheritance, and does that have a legal remedy or does that have any consequence that can be followed up on?
Now, Jordan, from a planning perspective, is there something that you can do if you're concerned that this disinheritance is going to cause a problem at the end of the day?
Right. What I try to educate the client about is the impact of a will. Clients often think a will is just, the document that gives away their property on death, but it's much more to their family. It's really the last thing that a parent says to their kid. It's in black and white. It's a lasting record. And you cannot discount the importance from an emotional point of view of that will on your children. So if you're just thinking, well, he's going to be fine with it or he knows it's coming, that's not enough, really. I think that you must recognize that what you're doing is basically saying to the child, I don't love you as much as my other children. That whether you mean to say that or not, that's what you're saying, and that's how it's written. And so you have to be very careful. The client has to be very aware of the emotional impact of treating children differently in a will.
Ian, from a drafting perspective, is there something that you can do that might make a will that does cut someone out stronger and less subjected to possible challenges?
Well, there are certainly specific drafting tools, and we can talk a little bit about those. The thing I remind my clients at the outset is that there are a whole flock of lawyers out there, and I include myself in this, who do estate litigation work as well. There's a whole flock of lawyers out there that ignore wills for a living. And there are ways to ignore that will from a legal standpoint, and that can have a profound impact on their shell game that they want to play here with the disinheritance. And the second thing is that if the will can be ignored legally, and it gets complicated in terms of when it can be, when it can't be, but it certainly can be ignored legally, then what is the financial impact to your estate? Like, let's just put a line item in your estate assets when you go through them, and let's just put round red brackets around it and say, guess what? I can't fill the number in, but I'm pretty sure it's going to buy a Muskoka cottage, all right, if we're going to get into litigation. Right. So those two elements of it are where I find clients, their heart rate drops a little, and they start to say, well, wait a minute, I know I kind of wanted a favor, I did want to cut one of my kids out. Let's start to manage that. Right. And let's talk about, and Jordy, you have a lot more experience on the drafting of those kinds of clauses, but putting right in the will document is an answer. It's only one approach you can take.
Well, I think, Ian, you're referring to the forfeiture clauses, yes, right? That say, look, if you're going to challenge this will and you lose, then you lose whatever benefit you're getting under the will. That only works, of course, if you're getting a benefit under the will. You can't, it's no encouragement to a challenger who's cut out completely of the will, right? So that has to, it's not a full safe remedy to the problem. But I think that what you have to do is manage expectations from the client's point of view. So the idea that anyone can challenge a will. People come in sometimes thinking the will is sacrosanct, and it is never going to be challenged. Well, anybody with $132 can challenge a will if they're an heir. So that's not, there's nothing I can do to prevent that. And sometimes I have to explain that. Yeah, right. For you, sometimes I have to explain that to the client because they think, well, it's a will. A will is a will. But as you say, there's lots of lawyers who ignore wills for a living.
And from a lawyer's perspective, is there anything that you do as a practice management thing that might assist in these situations if there is going to be a challenge at the end of the day?
Yeah. Two key elements of evidence on a will challenge, right, are doctor's notes and medical records, but the solicitor's notes. Mm-hmm. And so knowing that in the background and anticipating a will challenge, knowing that you're going to be a witness as the drafting lawyer, means that you've got to take copious notes. You've got to ask the right questions. You've got to dig down deeper. My son steals from me. That is not enough to have in your notes. The client says, son steals from me. Dig down. When? Who told you? Can the client actually dig down and drill down and explain the rationale for the change? But the other thing that I've started to do more regularly is I audio tape some of those conversations. So that's unusual. I don't think many lawyers do. But in a high-risk situation where I know that the client is planning on disinheriting, I want not only for the child to hear what their parent is saying about them, but also the court. And I think the best evidence that a court can have is listening to the testator say why he or she wants this to be the will. I mean, often the judges are left with just the lawyer saying, well, this is what the person told me. Well, isn't it better to have the actual voice of the testator saying it?
I struggle with that, and I do on two bases. One is courts have always struggled with how to manage that evidence,
right?
In terms of its not admissibility, but in terms of its impact. But the other is you are under hot lights with the form of questions, and the nature of the questions you ask are profoundly affecting the answers. As lawyers, we learn how to give a leading question and how to give a non-leading question, right. And it's an advocacy skill for which we happen to, it's a fundamental advocacy skill we all have to learn. If you're taping an hour-long interview, two things can happen. One is that the nature of the questions you've been asking for the last 20 years as you do intake may be, in fact, completely leading questions. Right. They may be leading the answer out of the witness for an hour. And so the tape gets played, and it has actually the opposite effect. It's like you guided the process. Right. So as a lawyer, if you're going to audio, you need to remember that you're on the hot seat there, number one.
Absolutely.
But number two is that people, and I think the difference is that where I agree with Jordy is that if we're going to do it, audio is a much stronger piece of evidence than audio visual. Because audio visual is difficult for a client to normally behave when they've got the cameras in front of them. As opposed to with a tape recorder in front of them, they'll get used to it, they'll start to ignore it, they won't be worried about the event of recording it quite as effectively, and they're not going to change their demeanor and their attitude toward it.
Right. I mean, it's quite, obviously you got to get the consent of the client beforehand, which I do, and I place it, and really, first of all, I've never had a client say no, and second of all, it really doesn't, it's just there and nobody really thinks about it. But it's important, but it's important anytime you're interviewing clients to have open questions because you're going to be cross-examined. If your notes say she said, son steals from me, you're going to be, what was the question? Well, you don't remember what the question was. So you can't obviously fudge when you've got an audio tape as to what the question was. And so, it's important to keep an open line of questioning.
Sometimes too much information is not good too. And so we get into that debate. But it's a tough call, and it all comes back to the same thing. If people want to choose to disinherit or inadvertently disinherit, there's a consequence for which there's no full answer and no complete way to resolve it.
Right.
So basically no foolproof way to disinherit?
That's true.
Okay. Well, thank you very much, gentlemen.
Thank you.
And thank you for joining us at Hull & Hull TV.